I'm saying the court had asked us to approach and talked about bond.
Because I'm putting everybody on notice where I am. That's why. Go ahead. You want to come at me? Let's do it.
I'm making a record as to...
No, go ahead and make your record. I'm just telling you where I am. Court calls case People versus Courtney Waldick.
For your honor, happened with Courtney Waldick. Judge, this is date time set for our second probable cause conference. At this time, if Waldick is inclined to waive her right to preliminary exam, and we've gone over those rights.
Waldick, is that correct? You're waiving your right to a preliminary examination?
Strap in, folks. This courtroom saga doesn't wait to heat up. From the moment the gavel drops in People v. Courtney Wall, sparks fly. With a fire in her eyes and zero hesitation, the defendant takes center stage, unapologetically declaring, "Make your record," as she waives her right to a preliminary hearing. It's not just defiance, it's a deliberate challenge hurled at the very heart of the legal system. The judge, unfazed but alert, swiftly affirms the procedural pivot, setting the tone for what promises to be a charged and unpredictable ride. Every second from here on pulses with tension, as the drama unfolds with the sharp edge of legal consequence and personal conviction.
Pardon?
Yes, I do waive, but in case this affects her pretrial date, I'd like to address bond if you have.
All right. So before I set the date, you may address bond. Go ahead.
Your Honor, at the time my office charged this case, we requested a $100,000 cash surety bond. At this time, I am renewing that request. I understand that Ms. Waldick was given a $50,000 10% bond at the time of her arraignment. When we were last before Your Honor, I did not have the benefit of certainly I still don't have the support because the investigation continues to be ongoing. However, the information that is now available to me has grown substantially since we were last here.
Tensions boil over as the prosecution returns to the spotlight, this time with sharpened intent. No longer settling for the original $50,000 bond, the state now demands a staggering $100,000 in cold, hard cash, driven by the weight of new charges: vehicular homicide. With a voice laced in urgency, the prosecutor lays it bare, for he caught this isn't some fleeting mistake. It's a deadly act under serious investigation. Newly uncovered evidence, grim and compelling, shifts the entire tone of the hearing. This isn't just about one defendant's freedom, it's about the lives at stake beyond the courtroom walls. The clash over bond isn't procedural, it's a high-stakes struggle, with public safety hanging in the balance.
On January 20th, the day of the crash, Ms. Waldick had been to a baby shower. She then went to Days in Ypsilanti with her friends, where she was drinking with her friends. She was texting people that were not present, somebody who was either her friend or her boyfriend. She had texted things to her boyfriend about meeting up with him later. In her text messages to her boyfriend, she indicated that she was out drinking with her friends and that she would be continuing to be drinking with her friends. She referenced to him that she wouldn't feel comfortable driving too far to meet him later, and I apologize for my language, but that she was going to be really hopped up. She did drive instead, though. She drove her car and she killed Miss Mason. After getting home, and I should say, she didn't stop. She did not call the police. After getting home,
the prosecutor draws the courtroom into a chilling morning, frozen in time, January 21st, 2024. As the sun rises, unsuspecting commuters come upon a devastating sight: the lifeless body of Ms. Mason lying by the roadside. The scene sends shockwaves through the community before investigators even begin to unravel the tragedy. In that moment, The courtroom shifts from formalities and filings to something raw and deeply human. No longer just a name on a docket, Ms. Mason becomes real. A mother, a daughter, a grandmother whose life was abruptly stolen. The weight of justice suddenly feels heavier, the stakes higher, as the case transforms into a solemn pursuit of truth and accountability.
Miss Waldeck saw her roommate's name, Sarah. And notably, we now know that Sarah actually drove that same route as Courtney a couple minutes ahead. Sarah did see Miss Mason alive and walking on the road. And Sarah initially told the police that she saw Miss Mason walking on the shoulder, which is consistent with physical evidence in this case as well. But when Courtney got home, and this is sort of Sarah's statement, as I understand it, as well as from the text messages that followed this, Courtney was quite hysterical. Courtney, excuse me, I'm gonna call her Courtney. Courtney told Sarah that she had hit someone and that she needed to go back. Courtney and her roommate took over an hour to return to the scene. During this time,
in a gripping narrative turn, prosecutors retrace the defendant's footsteps from the warmth of a midday baby shower to the blur of a late-night bar crawl. At the heart of it lies a haunting text message. She confesses she's too hoed up to drive. A moment of clarity, but one tragically ignored. Despite that warning, she slides behind the wheel, setting off a chain reaction that would end in irreversible tragedy. The carefree laughter of earlier hours fades into the sickening aftermath of a fatal collision with Ms. Mason. This is more than poor judgment hits, a breach of the unspoken responsibility we carry for one another's safety. The cost, a life lost, and a community left to wrestle with the weight of one reckless night.
However, when Courtney came in for her interview with the police, which mind you was the Friday following, so she came in for her interview on January 26th. The crash occurred on January 20th. She told the police that she believed that she hit a deer. This deer had just kind of popped out of nowhere, that she saw it just coming at her. We know from our interview with Sarah, the roommate, that Miss Mason was walking down the road. Sarah saw Miss Mason a couple minutes ahead of Courtney, and that Miss Mason was walking down the road. But what we also know is that Courtney didn't think she hit a deer. Sarah has now told us that Courtney came home and said, "I think I hit someone." Sarah has confirmed for us that there was no mention of a deer. So when Courtney got home, thinking that she hit someone, without calling the police or stopping to help that someone, she continued to tell her friends and her family what she had done and what stress she was under. She didn't call the police, leaving Miss Mason lying in the snow.
Surveillance shows Walk and Dole circling the crash site for over an hour, never calling 911, never helping. Their return to the scene, empty-handed and indifferent, paints a haunting picture of abandonment. Sarah's early police statements crumble against this chilling footage, revealing a disturbing gap between truth and action. What once seemed like tragic negligence now reeks of deliberate inaction. The courtroom feels that this wasn't just a lapse, but a cold rejection of basic human decency.
That if Courtney had just called the police, Miss Mason might still be alive. That's why we have crimes like this. That's why the penalties for crimes like this are so substantial, because Miss Mason may have still been alive and may still be with us right now. Miss Mason was a mother, she was a daughter, and she was a grandmother. And that woman was left on the side of the road without with any help being sent her way. But not only did Courtney not call the police and not attempt to save Miss Mason in any way, what I now know is that Courtney then deleted approximately 150 messages off of her.
In a stunning twist, The courtroom hears that Wall intentionally deleted around 150 text messages before turning over her phone. Among them, apologies, admissions of fear, and clear signs of regret wiped clean. This calculated digital purge screams consciousness of guilt, shattering her narrative of innocence. By scrubbing those messages, she didn't just erase evidence, she tried to erase accountability. It's a move that deepens doubt and shifts the case from tragic accident to possible cover-up.
She got home, and I know that defense counsel will argue that this was normal for her behavior, was she parked her vehicle in her garage. That car remained in the garage, and the garage door remained closed, as far as I understand it, with the garage inside. The police subsequently did a search warrant, and it wasn't until they were there with the search warrant that they were then given consent to go into the garage and discover the sheet.
The prosecution delivers a powerful blow, arguing that one 911 call could have saved Ms. Mason's life. With steady conviction, they drive home how a single decision made or ignored can change everything. This isn't just about poor judgment. It's about failing the duty to act when it mattered most. The point lands hard, turning simple negligence into a devastating, avoidable loss. It's an emotional reckoning, meant to stir the conscience of the court and demand justice for the defenseless.
Response.
Thank you, Judge. Obviously, I don't have to tell the court that Ms. Waldick stands here before you innocent until proven guilty. I'm not going to try the case in front of you, but I will address some of the things that were just said. First and foremost, there was an arraignment on January 28th where, as Ms. Hughes indicated, their office requested a $100,000 bond. A record was made. Prosecutor who attended the Zoom arraignment on that Sunday, myself, each made a record, and bond was set at $50,000, 10% with an alcohol tether. It's our argument to the court that that was not an unreasonable bond, nor was it an abuse of discretion. The fact that there's an ongoing investigation or this was charged early, that's not my client's fault. Maybe the prosecutor's office should have waited until the investigation was complete. With that said, Ms. Hughes indicates there was some drinking going on. My client turned herself in as a person of possible interest to the Washington County Sheriff's Department to Detective Webb on January 26th.
Surveillance and witness accounts reveal Walk quietly pulling into a sealed garage, shutting the doors tight the moment she got home. She kept it locked down until police arrived with a warrant and intentional move to block access. That delay wasn't just suspicious, it was strategic, risking the loss of vital forensic evidence. The courtroom feels the weight of it. This wasn't panic, it was a plan. Gasps ripple through the gallery as her quiet cover-up sparks outrage and disbelief.
Is the same Sarah who said she knew nothing about this originally. So now we have two different stories from Sarah, because originally Sarah said she had no idea what happened on the date in question. Ms. Waldick is now since the arraignment and before twice here on February 22nd for her. She's been compliant with bond the whole 2 months to today's date that she has been on bond since being arraigned, with an alcohol tether the whole time before she was released from jail, with absolutely no issues. So this is the second time before you, but including going to the Sheriff's Department to speak with Detective Webb, she's appeared 3 times. She's not a flight risk. In addition to being on alcohol tether and having no issues, she's also reporting, checking into community corrections weekly. I've heard nothing today regarding any bond violations because I don't think there are any. There's been no change in circumstances as we see it since the date of the arraignment. Ms. Waldick is definitely not a flight risk, and she's not shown that she's a danger to the community in the past 2 months at all. Again, there's been no allegations of that. Judge, the 8th Amendment of the U.S. Constitution indicates that the court shall provide a bail that is not excessive. Stack versus Boyle, 342 US 1, and People versus Edmond, 81 Mishap, 743 says bail that is set in an amount higher than reasonably calculated to give adequate assurance that the accused will appear is excessive under the Eighth Amendment. Edmond goes on to say that courts have held that money bail is excessive if it is in an amount greater than reasonably necessary to adequately assure that the accused will appear when her presence is required. Court rules are designed to enforce these principles, Judge, and under these rules, there's a double presumption that a pretrial arrestee will be released without any case bail requirement.
In their opening, the defense methodically leans into Walk's presumption of innocence, underscoring her voluntary surrender, spotless court record, and strict compliance with her alcohol tether. They portray her not as a threat or a flight risk, but as a cooperative, law-abiding citizen rooted in her community. With measured respect, the defense reframes the narrative, casting doubt on the prosecution's portrayal of evasion. This isn't about leniencies, about fairness, they argue, and upholding equal treatment under the law. The courtroom is left to weigh not just guilt, but the integrity of justice itself.
Already had asked to address bond, but you had mentioned it.
Well, counsel, if you want to point at me, I'll tell you exactly what I know about this case. What I know about this case is the warrants came to me. That's how I knew. And that it came to me because I'm in charge of all of these felonies and reviewing every bond that comes through. So that's how it came to me. So if you want to make dispersions against the court, go for it. Let's roll.
I'm not making dispersions. I'm saying the court had asked us to approach and talked about bond.
Because I'm putting everybody on notice where I am. That's why. Go ahead. You want to come at me? Let's do it.
I'm making a record as to...
No, go ahead and make your record. I'm just telling you where I am.
In addition, and obviously we know that search warrants aren't necessarily evidence. I appreciate that you know things or allege things because you were a party to the search warrants. In addition to what I've already indicated in terms of bond, she's not a flight risk. She's appeared at every court appearance. She's gone to the sheriff's department, met with Detective Webb. She consented to a release of and a search of her phone. She doesn't have any shown history of substance abuse or addiction, a mental condition. She's employed gainfully at a local hospital. She's got family members here. She's probably got about 5 family members here. She lives locally. She's got ties to the community. Again, bond is set at protecting the community and a flight risk. I think that what she has shown over the course of the past 2 months is she's neither. I'd ask that bond stay the same. Thank you.
Nothing further, Your Honor. Thank you.
Court, looking at the file and so that the record is clear, counsel came to the bench and the court was apprising counsel that the court had some concerns with the bond that was set. Neither counsel at that time was ready to raise the bond. There were certain things that...
In their opening, the defense methodically leans into Walk's presumption of innocence, underscoring her voluntary surrender, spotless court record, and strict compliance with her alcohol tether. They portray her not as a threat or a flight risk, but as a cooperative, law-abiding citizen rooted in her community. With measured respect, the defense reframes the narrative, casting doubt on the prosecution's portrayal of evasion. This isn't about leniencies, about fairness, they argue, and upholding equal treatment under the law. The courtroom is left to weigh not just guilt, but the integrity of justice itself.
Came to the court's attention that were not in the magistrate's mind, nor the magistrate's information at the time of the arraignment. I brought that to counsel's attention, quite frankly, out of fairness to both sides so that it could probably be argued before the court. What was not known, certainly to the magistrate at the time, was that there was this delay. There was information that was provided to the magistrate at the time regarding the defendant turning herself in, which was somewhat confusing as to how that occurred. And I apprised counsel of that. What my initial conclusion or what I saw was based upon what was presented to me prior to that hearing. Additionally, since that time, something that was not available to the magistrate were these text messages, which lead also to the defendant's knowledge, which play into this court's mind as to this defendant's danger to the public. Furthermore, there is, in terms of the issue of flight, of concealment of evidence and the like, now the deletion of text messages and other evidence in this case, which had just been alluded to, the deletion of basically evidence, which I think also bears upon the defendant's risk in this case. Also, the likelihood, the court can take into account the likelihood of conviction and other things as it regards to setting a bond. But certainly there is now clearly more information that's available to the court regarding this defendant.
When the judge returns, she delivers a measured yet piercing bench conference, unpacking a series of red flags, delayed reporting, mass deleted texts, and the hidden vehicle in a locked garage. Each revelation peels back what the initial magistrate never saw, building the case for a serious bond reconsideration. Her calm, detailed explanation silences the room, anchoring the moment in judicial authority. It's a sobering reminder that as new evidence surfaces, so too can the course of justice shift. The tone is clear. Accountability isn't static, it evolves with the truth.
The offense that was committed and the like. The court, I will also take into account the fact that I don't have any community corrections violations. I don't have anything along those lines. I do not believe that, given the information now available to the court, that the amount of the bond that was originally set, I do not believe that it is appropriate, and that additional bond would be required in this case. Defendant's bond, Mr. Allen. The defendant's bond in this case will be increased. I think that the amount requested by the people was an appropriate amount. Quite frankly, it was appropriate, but now knowing what I know, I would actually raise it beyond that, but I will not do so. In this case, her bond will be increased from $50,000 cash surety to $100,000 cash surety. Are they, counsel, just for the purposes of anything, are they able to do that right now? Or
we've made arrangements. There's a surety bondsman in the courtroom who can do that. If you can give us 15 to 20 minutes, it'll be taken care of.
She'll be taken back and do that. I think they can do that.
We need to arraign her on the information. I interrupted all of our proceedings.
Oh, okay. Yes, that's to the circuit court.
We'd waive the reading of the...
In a dramatic crescendo, the judge raises Walk's bond to $100,000, cash, sending a sharp, unflinching message. Concealment and cold inaction carry real consequences. The ruling echoes far beyond the courtroom, affirming that justice isn't just about facts, it's about integrity and responsibility. This moment marks the turning point where accountability finally eclipses remorse. It's a powerful reminder that the law doesn't just punish, it protects. If this breakdown brought you clarity, be sure to like the video, subscribe to the channel, and we'll see you in the next case.